This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Leibowitz is back with another court order ordering him to be honest and tell the judge what really happened. This is in the Chosen Figure versus Smiley Miley case, which we have not covered, I don't think. So we're just going to go over Judge Kaplan's order and see what it has to say. This is Judge Lewis A. Kaplan, District Judge for the Southern District of New York. So this is another Southern District of New York Leibowitz case. And he writes, plaintiff's attorney Richard Leibowitz has become quite well known for his failures to comply with court rules and orders, for having been sanctioned, and in a couple of cases for having lied to judges. Usherson v. Bandshell Artist Management collects a number of these cases. On July 29, 2020, in the wake of Usherson, Ward, and Rice, Mr. Leibowitz wrote to the court in this case saying that the parties had agreed in principle to a settlement and requesting a 30-day order. The court, concerned in light of Mr. Leibowitz's history as to whether he in fact had been retained by the plaintiff and authorized to sue and to settle, entered an order stating in relevant part the following. On or before August 6, 2020, Mr. Leibowitz shall file 1. A personal affidavit or declaration stating whether and when the plaintiff in this case specifically authorized him to file this action and settle it, and attaching any retainer agreement or other documentary evidence as to the foregoing, as well as a personal affidavit or declaration of the plaintiff stating whether and when the plaintiff in this case specifically authorized Mr. Leibowitz to file this action and settle it, and attaching any documentary evidence as to the foregoing. Failure to comply in all respects may result in the imposition of sanctions. So what the court is saying there is that they aren't sure that Mr. Leibowitz actually had authority to settle the case, and instead the court is concerned that Leibowitz settled the case only to avoid future or further imposition of sanctions or other burdensome requirements like having to file a bunch of the stuff from Usherson v. Bandshell and other cases. On August 6, 2020, Leibowitz submitted 2 declarations, one signed by him and the other by Josiah Kamau. The Leibowitz declaration asserts that on February 28, 2019, plaintiff via its principal, Josiah Kamau, signed a retainer agreement with the Leibowitz law firm, in which plaintiff authorized Leibowitz to file copyright infringement lawsuits on his behalf. It goes on to state that Mr. Leibowitz filed this action on June 23, 2020, almost 16 months after the alleged date of the retainer agreement, that he notified plaintiff on June 23, 2020, that he had brought this action, and that Mr. Leibowitz had plaintiff's authority to settle the case. It attaches what Mr. Leibowitz claims are copies of the signature page of the retainer agreement and an email to Mr. Kamau, notifying Kamau that he had brought this action in the name of an entity. Several points are notable about this declaration. First, Mr. Leibowitz did not comply with the court's direction to submit the retainer agreement. The purported signature page reveals nothing whatsoever about the alleged retainer agreement, and Mr. Leibowitz did not submit any documentary evidence as to anything beyond this page and the notification email. Second, Mr. Leibowitz claims that plaintiff, Chosen Figure LLC, authorized him to file this action, but the purported signature page of the retainer agreement that he submitted was executed on behalf of Mr. Kamau personally, and not on behalf of any corporate entity. Third, the purported retainer agreement was signed on February 28, 2019. This is nearly a year before the alleged infringement in this case took place, which the complaint makes clear was February 12, 2020. Whatever the terms of the agreement may be, the court does not know because Mr. Leibowitz failed to submit it, despite a clear order requiring him to do so under threat of sanctions. The agreement cannot possibly serve as evidence that plaintiff in this case specifically authorized him to 1. File this action, and 2. Settle it. The Kamau declaration avers that, on February 28, 2019, Kamau personally signed a retainer agreement with Leibowitz in which he authorized the firm to file copyright infringement lawsuits on his behalf, that Mr. Leibowitz had his authority to file the present copyright infringement lawsuit as of March 17, 2020, that Mr. Leibowitz notified him of the filing of this action on June 23, 2020 by email, and that Mr. Leibowitz had authority to settle the case. The declaration contains two exhibits, which are the same signature page and notification email attached to Mr. Leibowitz's declaration. It does not include any evidence supporting Kamau's claim that he gave Mr. Leibowitz permission to file this lawsuit on March 17, 2020, or to settle it at a later time. This declaration raises additional questions. Mr. Leibowitz claims that he had authority to bring this action by virtue of the purported February 28, 2019 retainer agreement. Mr. Kamau, however, declares that Mr. Leibowitz had authority to file the present lawsuit as of March 17, 2020. Mr. Kamau, however, declares that Mr. Leibowitz had authority to file the present lawsuit as of March 17, 2020, thus implying that the retainer agreement of February 28, 2019 did not authorize the filing of this action. And Mr. Kamau, like Mr. Leibowitz, has submitted no documentation apart from the purported signature page and the June 23, 2020 email. This court's order of July 30th required and still requires production of the full retainer agreement or agreements and all documentary evidence with respect to Mr. Leibowitz's authority to bring and settle this case. That includes all emails, letters, notes, and other writings or electronically stored information bearing on the retention, the scope of the engagement, including as it may have changed from time to time, and the settlement. All of this material shall be filed by Mr. Leibowitz and Kamau no later than August 18th, 2020. So ordered Judge Lewis A. Kaplan, August 11th, 2020. So that was just a couple days ago, and all that will be due on August 18th. So Leibowitz is once again setting up the dominoes to somehow fall not in his favor, and it appears like he doesn't want to give the judge the information the judge needs because that information might be adverse. Just like it was with Judge Siebel and the case with the mediator where he said his grandfather died, or wait, no, I'm mixing two things up. Those are two different Leibowitz cases. There was a case where he said his grandfather died, and that went before Judge Siebel. And then I think there was another case with a mediator that went before Judge Furman, Jesse Furman maybe, or maybe it was Siebel. I don't remember all of them at this time because there are so many. And that's exactly why no one should ever hire Richard Leibowitz, in my opinion, because he's probably not operating competently and honestly and, in all of his ethical rules and everything. At least we seem to have a whole bunch of stories about it. Let's see if we can find this declaration. So here's the declaration of Richard Leibowitz. These are unbelievably short. Serve as lead counsel, filed this action. There's a page from a retainer agreement and the email, and that's it. That's all he's supplied. So I can see why the judge would be a little bit upset. Here is the declaration of the Josiah Kamau person saying that they are the founding member of the thing and that they affirm what the judge said, that it could be filed and settled, but not providing any support or documentation. All that they provided was this part of a retainer agreement, which is just a signature page. It literally doesn't have anything saying that he's allowed to settle or commence cases. Here's the FYI for the case against Miley Cyrus, sure. And so yeah, that's nothing. I can see why the judge would be upset, as none of that supports the authority of Leibowitz to settle the case on behalf of the client. This seems like stonewalling at this point. And whenever someone, especially Leibowitz, starts stonewalling, I start to think that there's a reason why there's stonewalling. So, well, there's another Leibowitz case for you. Let me know what you think. Are you surprised that he's still walking, talking, and breathing as a lawyer, and that he hasn't been disbarred yet? I'm surprised. I'm a bit surprised. So maybe our surprise will be answered shortly. Otherwise, this looks really, really bad for other attorneys, for disciplinary committees and bar associations and Supreme Courts that all are supposed to be regulating the practice of law. They should not be allowing Leibowitz to continue just sabotaging our profession this way. It's despicable, unbecoming of a lawyer. Judges normally can't force lawyers to reveal confidential information about a client, even under threat of sanctions. And lawyers are counseled to hold their ground against overbearing judges who want you to violate the rules against confidentiality. But there is no rule saying that a retainer agreement is confidential information, and Leibowitz has the ability to object and explain what part of the communications he doesn't want to reveal are privileged information. And there are ways for the client and for Leibowitz to do an affidavit or declaration like we just saw without revealing confidential information. If Leibowitz is doing that, then he can simply say to the judge, here's the confidential information that we're redacting out. He doesn't have to say what it is in substance, but does have to say, this is communications about this or communications about that in the general sense, and then not reveal the confidential information. And if it really has to go much further and there's some kind of dispute that there's confidential information involved, then the judge can probably appoint a third-party neutral to not act as a judge, but rather examine a threshold question: is this confidential information or not? And if the third-party neutral agrees that it's confidential information, then they'll report to the judge, that's confidential information, you can't have it, and the judge will believe it, and end of case. I don't think that's what's happening here. I think the judge wants to know that the client gave authority to Leibowitz to settle. That's not going to be considered confidential information, just the yes or no, did they give authority or not. There's absolutely nothing confidential about your telling your attorney to settle or not to settle, or accepting a settlement or not accepting a settlement. Maybe the contents of a settlement, or maybe the discussions over why or what the client might desire, but the actual answer should not be considered confidential information. I don't think so. All right, that's our show, everyone. Thanks for joining me. Let me know what you think in the comments below. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, Floatplane, and Twitch. We are community supported, and we only exist because of your monthly support on patreon.com/ljfrench and sponsors.com/law. Thank you in August to our $50 plus supporters: Nicely Done Defense, Wes Delge, Citizen of the Sovereign, John Steele, Gavin Barnard, Evie, Kyle Mudrock, Spirit Bear, Jan Negray, Benjamin Hightoff, Steven, Blackleaf, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shiloh T, Rudolph Bescherer Jr., Oscar the Prophet, Jay Dixon, Hot Grills in Your Area, Ammonite, Engie, Brandon Abel, Torpidon, and Creative Corruptions. And thank you to the $5 plus supporters who... crap. And thank you to the $5 plus supporters who will be in the description of the videos. I love you all. I will see you in the videos that drop. Bye. Pretty cool building. Maximizes the service area while keeping everybody cool behind glass. Ah, the IMG building.